Tried to make me go to rehab. I said no, no, no. Yes, I've been black, but when I come back, no.
Welcome back to the PI show. Before the break, we were discussing rehabilitation after you're injured. Both work cover and TAC have obligations, but if you're injured in a public liability situation of slipping, falling outside of work cover and TAC, then you're at large.
Correct.
You don't have any, there's no one to provide medical support, rehabilitation, and so...
There's no statutory system, Harry, that's a problem.
No,
you don't
so there's no statutory scheme,
benefits. Yep.
And you're relying on common law ultimately to to make the wrong right.
You have you have some entitlements under Medicare and the Commonwealth Rehabilitation Service. The Commonwealth does pick up some of those issues for the obviously badly injured people, but they fall well short of the statutory work cover and TAC schemes.
And you've got to repay them.
You've got to repay them at the end of the claim as well.
And sometimes they can come into quite a few $1,000s.
Yeah, so there's significant. But both, we were just talking about both work cover and TAC, both have a scheme which tries to help workers get back to work. The current ad by Work Cover is an ad about a worker who's injured. I think it's a shoulder injury. He's very anxious about the first day back at work. He's with his family, goes to work, everything's very rosy, and everyone sort of congratulates him for coming back, and he tries to make a fist of it. He comes back to his family and he's relieved.
Yes.
Does that work in practice?
Oh, look, you get a lot of occasions where people say they're apprehensive about going back to work. They get called malingerers and that by other workers. But look, they've got to make an effort. The key to it is we encourage... Look, as a lawyer, I encourage them to go back.
The worker should make an effort, subject to talking to his GP.
Got to talk to the doctor. If the doctor's in doubt about what the job entails, they can organise their own occupational physician to go out to the employer.
All right.
Have a look at the duties.
And what about payments? If the worker goes back to work, what happens with his weekly payments?
If the worker goes back on reduced hours, the hours he's working, he gets paid his normally hourly rate. His compo payments are reduced for the hours that he's working, so his compo payments are reduced. So in effect, he gets paid his compo payments for the hours he's not working.
Okay, so it's a fair system. It works in a fair way.
Yeah.
Except work cover only pay 75%
at
of
this
your
stage
pre-injury earnings. So,
let's talk it might go
and
up.
I think TAC pay
80%.
80%. So there's a bit of a discrepancy in those two schemes.
My only concern, Harry, is that the word suitable employment. Obviously, if a person goes back into the workforce, they're not to put themselves at risk. There should be a proper assessment of their work duties before they go back. If there's any questions, that'll need clarification from the doctor, an occupational therapist and the employer together at an on-site meeting to work out what is the reasonable steps in returning to employment. You don't jump from the frying pan into the fire by putting somebody back into an unsuitable place of employment.
But what's important is that the worker goes back to work in this alternative job, and they've got to gauge themselves how they're going. And if they're having difficulties, they should tell their supervisor, they should tell their foreman, then go back to the doctor and explain what's going on.
Correct.
Keep a little diary if you need to. Just keep people informed.
Yep.
Yeah, and if you keep people informed, and if in doubt, get advice from a lawyer.
Yep.
Yeah, and then the next part of rehabilitation, I suppose, is that common law. The law says you've got to what's called mitigate your loss.
Yes.
That is, if you've lost your ability to earn money, you can't just sit back at home waiting for your court case to resolve in 2, 3 or 4 years' time.
We can't be a norm, Harry. You can't sit at home,
You've got to try and mitigate your loss. You've got to try and go back to work. You've got to make an effort to go back to work. So that's fair enough.
Yes.
No one can criticise that direction that the courts take. However, in work cover, you've got a situation where you've got to prove more than 40% loss of earnings.
Pre-injury earnings.
And you've got to be able to say you can't go back to your pre-injury employment.
Or any suitable.
You can't go back to suitable employment. You've raised suitable employment.
Yeah.
And the courts have considered suitable employment in Victoria a number of cases where we've had a 38-year-old butcher, born in Greece, came to Australia, and in effect, butchering's all he's known. He had a disc prolapse, and the work cover authority sent him to a number of experts
Yep.
who said, look, he can't go back to his butchering work with a serious back injury. I think he was operated. However, he can do alternate work, and there's a big argument in court about whether he could or couldn't do alternate work. What happened in the court case?
Well, the judge looked at his physical capacity, physical capabilities, and the judge said that all those jobs that they threw up.
Security guard?
Yeah, security guard.
Parking attendant?
Yeah, there was all sorts of
And
silly...
the other one is a petrol bowser operator. I think someone did a search, and I think there's about 5 petrol bowser operators left in Victoria. Everything's self-serve, Tony.
I wouldn't mind one of those. It saves when getting out of the car when it's raining, but it doesn't rain much in Victoria, so it doesn't matter.
But there's very few petrol bowsers. But WorkCover throw these up as options for people who say they can't go back to, a butcher can't go back to heavy physical work, but could be something else. And what do the judges do in those circumstances?
Well, the judge in that case found that he'd lost 40% of his earnings because of the fact of his physical capabilities. That's what the judge said. The judge threw out all those job alternatives. Yeah, he said it was. In fact, in one case, he said it was preposterous to throw those jobs up.
Yeah, the words in one judgment, Harry, are in this regard: it's unreasonable to expect an injured worker to undertake rehabilitation or retraining unless there is some real prospect, as distinct from merely theoretical or fanciful prospect, that the rehabilitation or retraining will open up employment opportunities. So there's a hell of a difference.
It's got to be a real
practical, not fanciful, not theory.
But the other case I was reading during the week was the case of a 51-year-old timber worker, and he hurt his hand. He lived in Cann River, and the judge in that case, what happened?
In that case, he obviously succeeded in relation to his
pain and suffering. He had a nasty. He lost some fingers on the right hand.
On a saw blade. In relation to the rehabilitation and the ticket for
loss of
income, there were some other factors to be taken into consideration. One was that he had lost his licence because of an alcohol-related offence.
So he was living in Cann River?
Yes, and he said in evidence that other workers that had been retrenched had moved on to the next town or driven across to the next town to work. He obviously couldn't do that because of his loss of licence. When they put all the facts together, unfortunately he didn't succeed in proving on balance of probabilities that he was able to get a serious injury for that aspect.
It was a pretty tough decision because, the other towns were 140 kilometres away.
It's the scales of justice, Tony.
Yeah, well, I think they tipped the wrong way.
They tipped the wrong way in that case.
Well, we all know the discharge, they have to discharge the burden of proof.
Yeah.
He hadn't been able to do
there was evidence in that case that he didn't have money to pay for a bond.
Yep. Yeah.
He didn't have money to pay for the first month's rent.
The scales of justice weren't quite right.
A bit unlucky.
That's all we've got time for. We're having a break. We'll come back after the break.
Thank you.